Well, Chaney, I can tell you a lot of it was procedural. So we just walked out. I'm sorry, it sounds like we're getting some video from the courtroom now. Well, I can tell you that moments ago we just walked out from the
presiding over this
here.
case. So, Mr. Kohberger, you've already heard a lot of what I'm going to tell you, your initial appearance, but I'll repeat it to you because it's important, and I want to remind you of these issues. So I'll briefly cover your rights, the charges against you, and the maximum penalties if you are found guilty or if you plead guilty. So I'm going to start with the rights. You have a constitutional right to have an attorney represent you throughout these proceedings. If you cannot afford to hire a lawyer, then one is appointed at public expense. Ms. Taylor and her team have already been appointed, so that's taken care of. You have a right to a speedy and public jury trial where the state would be required to prove every element of each charge against you beyond a reasonable doubt. At that trial, you would have the right to cross-examine the witnesses called against you. That means to see, hear, and question them, to call witnesses to testify for you, and if you choose to testify in your own defense. But you're not required to testify because you also have a right of silence. That right is protected under the Idaho and federal constitutions, so you can remain silent throughout these court proceedings, and that can't be held against you in any way. What you do need to remember, though, is that anything you do say other than to your lawyers could be used against you in a later court proceeding. Do you understand that?
Yes, I do.
Okay, thank you. You also have a right to appeal any final decision of the court. In order to exercise that right, you need to file a notice of appeal within 42 days of that final decision, or that right is waived. Also, if you are not a United States citizen, any finding of guilt in this state could have adverse consequences to your legal status. Do you understand these rights?
Yes.
Any questions about the rights?
No.
All right. Thank you, Mr. Kohberger. So let's go to the indictment. Do you have a copy of the indictment in front of you?
Yes.
Okay, thank you. And you see in the heading your name there. Is that your correctly spelled complete name?
Yes, it is.
Is that the correct birth date underneath your name?
Yes.
Are those the correct last four digits of your social security number?
Yes.
All right, thank you. All right, I'm going to read you the charges on the indictment. Starting with count 1, burglary. That is a felony under Idaho Code Section 18-1401 and 1403. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder. Count 2, murder in the first degree. That is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan from which she died. Count 3, murder in the first degree, a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Kayla Gonzalez, a human being, by stabbing Kayla Gonzalez from which she died. Count 4, murder in the first degree. That's a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. Alleging that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Zana Kernodle, excuse me. This is hard, I'm sorry. Zana Kernodle, a human being, by stabbing Zana Kernodle, from which she died. Count 5, murder in the first degree. This is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. This was signed on May 16, 2023, by the presiding grand juror. So now I'm going to go to the maximum penalties of each charge, starting with count 1, burglary, minimum 1 year, up to 10 years in imprisonment, fine of up to $50,000 or both fine and imprisonment, restitution for the victim's economic losses resulting from the crime. For counts 2, 3, 4, and 5, murder in the first degree, maximum penalties, life in prison or the death penalty. Fine of up to $50,000 or both fine and life in prison or the death penalty. Restitution for the victim's economic losses resulting from the crime. Also additional fine of up to $5,000 to be paid directly to the victim's families. If you are found guilty or plead guilty on each charge, and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive life sentences or death penalties, fines of up to $200,000 and $20,000 to be paid directly to the families with any restitution resulting from the crimes. Okay. Kohberger, do you understand the charge in count 1, burglary?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 2, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 3, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 4, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 5, murder in the
Yes.
first degree? Do you understand the maximum penalty?
Yes.
And Ms. Taylor, is Mr. Kohberger prepared to plead to these charges?
Your Honor, we will be standing silent.
And because Mr. Kohberger is standing silent, I'm going to enter not guilty pleas on each charge, counts 1, 2, 3, 4, and 5. Now at this juncture, the state has 60 days to give notice of intention to seek the death penalty. And Mr. Kohberger has a constitutional and statutory right to a speedy trial. So let's start with you, Ms. Taylor, and then Mr. Thompson to discuss some scheduling.
Your Honor, we'd ask the court to set this trial at the very outside of the speedy trial, right? We're not prepared to do anything but ask the court to do that today.
Okay. Count it out, and that would be.
I have not counted it it out, Your Honor, but I believe it would be about November 22nd is when it's maybe November, somewhere around there. So I'd ask the court to set it for an October trial date.
How long do you think it'll take to try to case?
My best guess is it would take at least 4 weeks, maybe 6.
So you'd like me to set this for a 6-week trial?
At this point, I would, Your Honor.
And to do so, I will have to get rid of some of the other 3 trials I have, but it's more critical and more important. So, Mr. Thompson, what's your...
Those trial dates are workable for the state judge.
About October 2nd, I started. Okay, for 6 weeks.
Yes, sir.
Anything else we need to address today, Ms. Miller?
Not with regard to the trial setting, Your Honor.
Anything else?
No.
Thank you. Counselor?
Nothing for the state at this time, Your Honor.
All right. So with that, by the way, I do want to let everybody know, if they don't already know this, that once the grand jury issued the indictment, the preliminary hearing scheduled to start on June 26th was no longer needed and was vacated. So some people are confused about that. So I thank counsel and media and the public for your attention and respect. So we are adjourned. Thank you.
And there you have it. You see Kohberger walking out of the courtroom there. The arraignment just wrapped up about 15 minutes ago. That was a playback because streaming was not allowed inside the courtroom. So what we can tell you right now is that Kohberger's trial date is set to begin in October on the 2nd at 8:30 in the morning. This arraignment comes after a grand jury found that there was enough evidence for this case to go to a full trial. So I was sitting right next to the Gonsalves family, right behind them. You could tell that it was a very emotional day for them. We were here as they walked up to the courthouse, and Kaylee's mother, Christy, she said hello to us before they walked into the courtroom. But right now, they are getting ready to attend another scheduled conference for that gag order hearing. Let's show you video from inside the courtroom. Kohberger walked in just after 9 o'clock. He was in an orange jumpsuit. He did give a little grin to his attorney. Ann Taylor before he was seated, and then we heard from Judge John Judge, who introduced himself as the new judge presiding over the case. The judge really went over a lot of procedural things, including reading Kohberger his rights. Kohberger said very little. He responded with, "Yes, I do," and yes, and then he said he didn't have any questions. And then the judge went over each charge Kohberger is facing, including reading the names of the victims and how they were killed. And as soon as they got to Kaylee Gonzalez's name, the family became very emotional there. Kohberger, I should mention, facing 4 murder charges and 1 burglary charge. And then pretty much the entire arraignment, Kohberger kept his gaze forward at the judge, not really showing much emotion as the judge read each of the charges. So the judge also read some of the possible penalties, including fines, jail time, restitution to the families. We didn't hear until the very end about the death penalty, but the judge did mention that at the very end. Ann Taylor did say that when the judge asked how Kohberger wanted to plea, or if he wanted to enter a plea today, that they were going to, that they were standing silent. So this is under the Fifth Amendment. This doesn't mean that he's pleading guilty or not guilty, but the judge does enter it as a not guilty plea. So right now we can tell you that Ann Taylor saying that she needs just outside of the speedy trial time frame to get ready for trial, and that is why it is scheduled for October 2nd. She asked for as late as November 20th, and asked for at least 6 weeks for the trial. Again, we are following this very closely, and I believe we're going to send it now to Channing in the studio with more insight on today's arraignment. Channing?
All right, thanks, Tim. Let's get right over to criminal defense attorney and legal expert John Henry Brown, who's joining us live this morning to talk more about this arraignment and possible next steps even for this case. So, John, first of all, thank you so much for joining us this morning. I want to get right to the question about the suspect's decision on standing silent and not actually verbally saying or entering a plea. Can you explain a little bit about what that means?
Well, it's not uncommon, and it really doesn't have any legal significance. The judge enters when you don't say not guilty or guilty, which of course wouldn't happen in this case. The judge will normally enter pleas for you, and that's usually always not guilty. So that's not really very unusual. It doesn't really have a lot of meaning.
And so let's talk about next steps, because we do know now that the trial will begin, or is set to begin, October 2nd. And the attorney for Kohberger actually asked for a slightly longer. She actually asked for it to be pushed as far back as November. Do you think that what do you think that the defense is now working on at this time?
Well, that's a really early trial date for a death penalty case. I'm assuming that date will be continued again. In cases like this, I've read a lot of the material that's online in the court pleadings, and I'm sure there's a lot of DNA evidence that may or may not be questionable. There'll probably be a battle of the experts on DNA and perhaps some other crime scene experts. So I think an October trial date is very optimistic. The death penalty cases I've handled, we had more than a year at a minimum to prepare for trial.
And of course, probably one of the best known cases that you are known for representing, of course, is Ted Bundy. And so you have tons of expertise in dealing with cases of this magnitude. Is there anything else that people should know about who aren't necessarily as familiar with the legal system in trying to follow this case?
Well, it's not well known, but it's true. And I actually wrote a book, but I'm not plugging it. But I got a plea bargain for Ted involving 4 states that if he pled guilty in Florida, he would avoid the death penalty. And it took a while, but myself and another attorney talked him into it. He signed the paperwork. We walked into court, and he said he's not going to do it. And that was the last I decided to help him. Basically, if you want to die, then I don't have time for you. I would think in almost all cases involving the death penalty, there's rigorous plea bargaining going on. When I represented Sergeant Bales, who was charged with some homicides in Afghanistan, it was a death penalty case, and we resolved that case by taking the death penalty off the table after a lot of work. And here, see, in Idaho, you get preliminary hearings. We don't in Washington. Normally, if you're indicted or charged by information, you don't get a preliminary hearing. Preliminary hearing could be very interesting in this case. It's a preview. It's a preview of what the government has, and the defense has a good opportunity to question the evidence and get more information at a at a preliminary hearing. It's interesting that there's a book that's recently released called Justice in the Time of Judgment by Anne Bremner, B-R-E-M-N-E-R, and her brother Doug Bremner. It's an excellent book for everybody involved in this to read because it's very timely, because the question they ask is it possible to get a fair trial in the time of social media? And I personally, unfortunately, think it's not. That social media has really changed the presumption of innocence and proof beyond a reasonable doubt. I'm sure there's thousands, if not millions, of texts and emails and posts on this case. I'm sure most of them are against the defendant. So it's a really interesting book because they came to the conclusion, and Anne Bremner was a longtime prosecutor, very well known, and it's a really good book. But I don't think it's possible to get a fair trial anymore with a case where there's a lot of pretrial attention. You know, in Canada, it's against the law to have pretrial publicity of any kind.
No,
the reason they do that is, it's very interesting.
And that's actually another one of the things that has many people talking, of course, is the gag order that we will be hearing a little bit more on a little later this morning. But that gag order issued out by another judge, actually, one of the reasons they said for it was so that there would be access to a fair trial. Do you think a gag order in this case actually does help the proceedings?
Well, I think it certainly indicates that judge, which was really trying the best to provide this defendant with a fair trial. But I think the cat's out of the bag. First of all, no judge can prohibit citizens in general from making comments online or live or written. The only jurisdiction the court has, you'll probably like this because I don't think the judge has jurisdiction to silence the press. I think that's I hope you have good lawyers on that because I think the judge only has jurisdiction over the parties, which would be the state and the defendant and his defense team. But I was very impressed. I read the order. I was very impressed that the judge is trying to do I think it was a male judge, his best to silence the pretrial publicity. But that would never happen. I mean, he may enter the order, but the damage has already been done. I mean, I don't think Mr. Kohberger, and I'm no fan, obviously, but I don't think Mr. Kohberger can get a fair trial anyway.
Well, John, I want to thank you so much for your time this morning. We have to wrap things up right now, but I understand that you will be back with us live on the KREM 2 News at noon. And of course, for the latest information on this case, you can text us the word Moscow to 509-448-2000. We will send you a link to all of our reporting right to your phone. And of course, we'll have much more on our continuing coverage on the KREM 2 News at noon and Force It Forward.